Let me ask you something important right out of the gate. Have you ever signed a contract because you felt rushed, overwhelmed, or trusted that everything would be fine? If you're nodding along, you're not alone. And when it comes to assisted living contracts, that exact moment is where many smart, careful seniors end up trapped. Today, we're talking about one powerful sentence, just one, that can mean the difference between freedom and a financial nightmare. It's called an exit clause, and if it's missing or weak, a bad assisted living contract can quietly drain your savings before you even realize what's happening. In this video, we're going to talk about how this clause works, why it matters more than any glossy brochure, and how to protect yourself before you ever sign your name. Let's start with something most people don't expect. Assisted living isn't just about care, it's also a business, a very well-designed one. These communities are built to look warm, friendly, and reassuring. Fresh paint, smiling staff, maybe even cookies on the counter when you tour. But behind that friendly front is a legal document written to protect one side first, and it's not usually yours. That's why the exit clause matters so much. It's the only part of the contract that clearly spells out how you leave, what it costs, and how much control you keep if things don't work out. Here's the part that surprises people. Many seniors think the biggest risk is moving in. In reality, the biggest risk is trying to leave. I've seen contracts where someone wanted out after just a few weeks. Maybe the care wasn't what was promised. Maybe the food was terrible. Maybe their health changed. And that's when they discovered the contract required 30, 60, sometimes even 90 days notice. During that time, they were still charged full rent, full fees, even if they weren't living there anymore. That's not rare. That's common. So here's the first thing to understand about a strong exit clause. It must clearly state how much notice is required to leave, and it should be reasonable. Reasonable doesn't mean whatever the facility says is standard. Reasonable means it protects you if life changes suddenly, because life does change suddenly. A fall, a hospital stay, a need for higher level care. If your contract says you owe thousands of dollars just because your health took an unexpected turn, that's not care, that's a trap. Now let's talk about another detail most people miss: refunds, or more accurately, the lack of them. Some assisted living communities charge large upfront fees, community fees, entrance fees, administrative fees. The names vary, but the result is often the same. Once that money is paid, it's gone. A good exit clause spells out exactly which fees are refundable and under what conditions. A bad contract stays vague on purpose. Vague language like "at the discretion of management" should immediately raise a red flag. That's legal talk for "we decide, not you." Here's a real-life example I want you to picture. A woman in her early 70s moves into assisted living after her children encourage her to try it for a year. 3 months later, she realizes she hates it. She feels isolated, the care feels rushed, and it's not what she was promised. She gives notice and then learns she owes 2 more months of rent plus forfeits a $4,000 community fee. That money was supposed to be her cushion. Instead, it vanished because the exit clause didn't protect her. And this brings us to another quiet danger. Many contracts allow the facility to terminate you, but don't give you the same power in return. That's right, some agreements let the community remove a resident with little notice if their care needs increase, while still holding the resident to strict financial penalties if they choose to leave. A fair exit clause works both ways. If they can end the contract with 30 days of notice, so should you. Anything else is one-sided. Now, if this is already making you uneasy, that's actually a good thing. It means you're paying attention. And if this information is helpful so far, take a second to like this video and subscribe to the channel. I share this kind of plain-spoken guidance because no one should lose their savings just because they trusted the wrong paperwork. Subscribing means you'll have this knowledge before you need it, not after it's too late. Let's ease into something just as important, but rarely discussed: timing. Some exit clauses only allow you to leave at specific times, like the end of the month. That sounds harmless until you realize leaving on the second day of the month could still cost you 28 more days of fees. A strong exit clause allows prorated charges. That means you pay only for the days you actually live there. Anything else quietly benefits the facility, not you. And here's where I want you to lean in a bit. You should never rely on verbal promises when it comes to exiting. If it's not written into the contract, it doesn't exist. Staff turnover is common, and what someone assured you during the tour won't matter later. The exit clause is the only promise that survives management changes, staff changes, and policy shifts. As we keep going, we're going to talk about the exact wording that gives you real leverage, how to spot sneaky language that looks harmless but isn't, and how to push back, yes, even negotiate before you sign anything. Because once you understand how this clause works, you'll never look at an assisted living contract the same way again. Now here's where things get interesting. Because once you understand that the exit clause is your safety net, the next question becomes how strong that net really is. This is where the wording matters more than the promises, more than the smiles, more than the tour. A single phrase can decide whether you walk away clean or stay financially stuck. And most people never slow down long enough to read this part carefully. Let's talk about one word that shows up in bad contracts all the time: may, as in the community may refund unused fees, or the community may waive additional charges. That word sounds harmless, almost polite, but legally it gives them total control. May means optional. It means they can say no, even if your situation is heartbreaking, even if you were there for only a short time. A strong exit clause uses firm language. Words like will or shall matter. They lock expectations in place, so there's no guessing later. Another detail that deserves your full attention is what triggers the exit. Some contracts only allow penalty-free exits under very narrow conditions, like death or transfer to skilled nursing. That means if you leave because the care quality drops, or because you feel unsafe, or because the costs suddenly jump, you could still be penalized. A fair exit clause allows you to leave for any reason with reasonable notice. You should never need to justify why you're protecting your own well-being. Now, let's slow down and talk about notice periods again, but from a different angle. Many facilities frame long notice requirements as standard practice, but standard for whom? Not for the resident. Long notice periods exist to protect the facility's cash flow, not your peace of mind. If a contract demands 60 or 90 days of notice, ask yourself this: could I afford to pay that if I had to leave suddenly? If the answer is no, that clause is dangerous. And here's the part people don't realize: you can ask for it to be changed. Yes, you heard that right. Assisted living contracts are not carved in stone. They are negotiable far more often than facilities admit. They may push back, they may say they don't make exceptions, but exceptions happen all the time, especially when someone asks before signing. Even a small change, like reducing the notice period or adding prorated billing, can save thousands later. The exit clause is the most negotiable part because it's the least visible during tours. Now here's something that catches people off guard. Some exit clauses allow the facility to continue charging fees until the unit is re-rented. That means you could move out, return your keys, and still owe money for weeks or months because someone else hasn't moved in yet. That shifts their business risk onto you. A strong exit clause clearly states that your financial responsibility ends on a specific date, regardless of occupancy. Let's talk about health changes, because this is where reality often clashes with contracts. If your care needs increase and the facility can no longer accommodate you, the exit clause should protect you from penalties. Otherwise, you're punished for something you can't control. Look for language that waives notice requirements and fees if the facility initiates the termination or cannot meet your care needs. If that language isn't there, that's a serious warning sign. Now, imagine this scenario. A couple moves into assisted living together. One spouse's health declines faster than expected, and they need a higher level of care. The other spouse wants to leave too, to stay together. Some contracts treat these as two separate exits, doubling notice periods and costs. A fair exit clause accounts for couples and shared decisions. If the contract ignores this possibility, it's incomplete at best and exploitative at worst. Another subtle issue is automatic renewals. Some contracts quietly renew month to month unless you give notice within a specific window. Miss that window and you're locked in again. A strong exit clause makes renewal terms clear and simple, without traps or fine print. If you need a calendar reminder just to avoid penalties, something's wrong. And let me say this gently but clearly. If you feel pressured to sign quickly, especially with phrases like, "this unit won't last," or "prices are going up next week," slow everything down. Pressure is often used when contracts don't hold up well under scrutiny. A good facility will give you time to review, to ask questions, even to have an attorney or trusted family member look things over. A bad one counts on you not doing that. Here's something empowering. You don't need to understand every legal term to protect yourself. You only need to ask a few direct questions and insist the answers appear in writing. What happens if I need to leave suddenly? How much will I owe exactly? When does my financial responsibility end? If the answers feel slippery, that's not confusion, that's information. As you let this sink in, remember that the exit clause isn't about planning to fail. It's about planning to stay in control. Life changes, needs change, feelings change. A good contract respects that. A bad one punishes it.
Now, let's bring this home in a way that actually helps you feel confident, not cautious or afraid. Because the goal here isn't to make you suspicious of every assisted living community. There are good ones out there. The goal is to make sure you never sign away your freedom without realizing it. Once you know what a healthy exit clause looks like, you can spot a bad contract almost immediately. And that alone puts you back in control. Picture yourself sitting at the table with the contract in front of you. You don't need to read every page in order. Instead, flip straight to the section about termination or moving out. If it's buried deep, written in dense language, or feels intentionally confusing, that's your first signal. Clear contracts don't hide important information. A strong exit clause is easy to find and easy to understand because it has nothing to apologize for. Here's another moment that matters more than people realize. Ask what happens if the facility changes ownership. This happens all the time. When ownership changes, policies often change too. A solid exit clause states that your original terms stay intact, even under new management. Without that protection, new owners can enforce stricter rules while holding you to the same penalties. That's how people end up shocked by fees they never agreed to emotionally, even if they technically agreed to them legally. Let's talk about leverage, because this is where many seniors underestimate themselves. You have more power before you sign than at any other moment. Once your name is on that paper, the balance shifts. If something in the exit clause feels unfair, you're allowed to say, "I'm not comfortable with this." You're allowed to walk away. And here's the truth. If a facility refuses to make even small adjustments to protect you, that tells you exactly how they'll treat you once you move in. There's also something reassuring I want you to remember. You're not being difficult by asking questions. You're being responsible. Assisted living is one of the biggest financial decisions many seniors make after buying a home. You wouldn't buy a house without understanding how to sell it later. This is no different. The exit clause is your resale plan, your emergency door, your safety valve. Now, let's gently address something emotional, because it comes up often. Many seniors feel guilt about questioning contracts, especially when family members are involved. They don't want to seem ungrateful or resistant.
But protecting yourself isn't a rejection of help. It's a way of making sure that help doesn't turn into harm. The right community will respect that. The wrong one will rush you past it. If you've stayed with me this far, do me a small favor. Like the video and subscribe to the channel, not because it helps an algorithm, but because this kind of information is easiest to find before you need it. Being subscribed means you'll keep learning how to protect your independence, your money, and your peace of mind. As we wrap this up, let's take a breath together. You don't need to memorize legal language. You don't need to be confrontational. You just need to slow the process down and insist on clarity. A good exit clause gives you flexibility, fairness, and dignity. A bad one takes those things quietly. If you've already signed a contract and something feels off, you're not powerless. Many states have consumer protection rules, cooling off periods, or ombudsman programs that can help. And sometimes simply understanding the contract gives you enough confidence to start a productive conversation with management. I'd love to hear from you. Have you or someone you love faced challenges with an assisted living contract? Was there something you wish you'd known earlier? Share your thoughts in the comments. Your experience could help someone else avoid a costly mistake. Remember this above all else. You've earned the right to feel safe, respected, and in control at every stage of life. Don't let fine print take that away from you. Here's to making smart choices, asking the right questions, and living your best life with confidence, no matter your age.